cyber security strategy of UK. UK government has adopted cyber security strategy for safety and security of the citizens of UK in future, so that people and business houses and government can enjoy the full benefit of the cyberspace. UK government wants to implement this strategy by effective law enforcement and proper judicial response to the cyber crime cases. Aim to adopt this strategy to achieve the following. What are they? To create a hostile environment for a cyber criminal by law enforcement and implementation and comprehensive understanding of scale and scope of cybercrime. So they should scare about they should scare before doing any criminal act. So the environment is such type, it's not at all friendly for them, so they can think 10 times before committing any such type of criminal acts. To coordinate among different government agencies at ministerial level and to review all available legislation relevant to the cybercrime. Sometimes we know that there is a good lot of interfaces. So gradually we can see how UK government cover the vast number of legislation, which one is, I mean anyone is related with cyberspace, they try to cover cybercrime like Defamation Act is related with cyber, or the telecommunication related with cyber. So wherever there is a scope to address cybercrime, UK government try their best to cover through all this legislation to have a point for the cybercrime. And if there is a coordination between different government, it is very much easier to locate or very much easier to handle the situation. To ensure standard data handling with proper measures of safety and security, to create awareness among public and to gain public confidence by provisions of information regarding cybercrime, that is very much important to get the awareness. If the public is knowledgeable about that, they can create their own measure even. But most of the cases they are not aware of the cyber crimes or cyber criminals, or they cannot assume or presume what is going to happen. If they can assume, they can take their own precaution. Coordinate between internet industry, stakeholder and commercial business houses in order to better control of cybercrime issues, to create international coordination for effective handling of cyber crimes. The law of UK related to the pornography obscenity in electronic medium. This is increasing day by day and it's very threatening. It's a huge industry, billion pound, billion dollar people are earning through this child pornography and pornography through the electronic medium. Now, UK is having especially the Obscene Publication Act 1959. Obscene Publication Act 1959 actually prohibits the publication of obscene matter irrespective of the motive of such publications, whether or not for gain. In case of any such publication by anybody, causes criminal liability and provide imprisonment for 6 months for the first time conviction, next time conviction 3 years more with fine or without fine. In the Amendment Act of 1964, provisions for scope of conviction is further broadened by including the concern regarding ownership, possession and control of obscene matter with any person who has the intention of publications for such matter for material gain. Now, what can be termed as obscenity? There are certain tests for the obscenity. Actually, as a whole, we can say any content which can affect or which can corrupt the mind, maybe the content as a whole or part of it, which can tend to deprave or corrupt person who are likely having regard to all relevant circumstances after reading, after seeing, after hearing that particular matter. So this is called the obscenity. Film exhibition or anything said or done in the course of the film exhibition which is considered as obscene, indecent, offensive, disgusting or injurious to morality is also included in this particular purview. This is particularly relevant for today's today, as more films, short films, documentaries, videos are made and published nowadays through the internet, and then before there is a good lot of chances of the publication of obscenity in more frequent than the earlier. One immunity is provided through this act for persons in possession of obscene material, and that is to provide that he has not examined the article in respect of which he is charged. Now, regarding the child pornography, there is a Protection of Children Act. Child pornography is a very popular way of cybercrime, and people engaged in such activity is regarded as more vulnerable for the society. For the purpose of Protection of Children Act 1978, indecent photographs of children, making, possessing it, distribution, advertisement, publication is a serious offence. Provisions of seizure, search, forfeiture of this material is provided in this particular statute. Offences under this act is punishable with imprisonment up to 6 months or a fine £1,000 or any other sum as prescribed by the relevant judicial authority, or both. Even section 1 of this particular acts further defines indecent photograph of a child under age of 18 years, read together with amendment section 69 of Criminal Justice and Immigration Act 2008, and explicitly includes the digital image as well. So there are certain provisions, statutory provision, tracing or other image, whether made by electronic or any other means, which is not itself a photograph, may be a pseudo photograph. Data stored computer disk or computer means which is capable of conversion into an image within the pseudo photograph or photograph in relation to the child pornography. This again is very much time relevant provision, as child pornography, like adult pornography, is also practiced through the electronic communication system and internet. As I have told earlier, Telecommunication Act also they related with they give a cross referencing with cybercrime. Current area of booming information technology, telecommunication is provided along with the internet service, both using the electronic communication technology. So the section 43 of the Telecommunication Act 1984 specifically takes care about the improper use of the public telecommunication system, and held the person who sends by means of a public telecommunication system a message or other matter that is grossly offensive or an indecent, obscene or mincing character, or sends by those means for the purpose of causing annoyance, inconvenience or needless anxiety to another, a message that he knows to be false or persistently makes use for that purpose of a public telecommunication system, guilty of the offence and held such person liable on summary conviction to the fine not exceeding level 3 on the standard scale. So moreover, a person who is running the public telecommunication system during his course of business intentionally modifies, interferes with the contents of a message sent will be held guilty of an offence, will be liable for the summary conviction. Now, if a person intentionally intercept a message by electronic means where a message to send has been intercepted, intentionally discloses to any person personal contents of the message, shall be guilty of the offence. Now, Communication Act 2003 also having a cross referencing of cyber crimes. Communication Act 2003 has given the regulatory authority regarding communication matters to the special body called Office of Communication, Ofcom. It is the duty of Ofcom to secure the communication through all radio and television services, to provide adequate protection to public from the inclusion of the offensive and harmful material, unfair treatment in the program, unwarranted infringement of privacy resulting from activities carried on for the purpose of such services, protection of children as they are more vulnerable of offensive program, prevention of crime and disorder, protection from any matter which may have a significant impact on persons carrying on business in any of the relevant markets, matter likely to have a significant impact on the general public in the United Kingdom. Now, actually duty of the Ofcom to encourage the development and use of technologies and system to regulate access to such material and for facilitating control over what material is received and both effective and easy to use. So, publication of any information in mass media is to be regulated by Ofcom. Confidential matter should be confidential in the form, that is the Ofcom duty. According to the statute of the Ofcom, should consider appropriate security and for the end user and public electronic communication services. Now, law of UK relating to the liability of internet service provider. Now, we know that ISP, internet service provider, they are actually providing the internet services. They are giving a platform to run the internet or to run the network. The Electronic Commerce Regulation 2002 takes care of the regulation regarding electronic commercial activities throughout the European community. Now, appropriate enforcement authority has to take care of prevention, investigation, detection, prosecution of criminal offences, including the protection of minors and the fight against any incitement to hatred on grounds of race, sex, religion, nationality and a violation of human dignity concerning individual person. In respect of Information Society Service, Enforcement Authority shall not take the measure to above unless it asks the member state in which the service provider is established to take measures and the member state does not take such measures or they are inadequate. So, it is a EC directive, they are just giving a guideline or the European community member countries guideline how to control the e-commerce and how should the ISP should be regulated for the benefit of the e-commerce to stop the cyber criminals. Wherein information society service is provided which consists of the transmission in a communication network of information provided by a recipient of the service provider shall not be liable for damages or for any other pecuniary remedy or for any criminal sanctions as a result of the transmission where the information is the subject of automatic, intermediate or temporary storage, where that storage is for the sole purpose of making more efficient onward transmission of the information to other recipients of the service upon their request. So, here they are very much specifying where ISP is not having any liability. So, for this acts they are not liable, and also to avoid the liability has to make sure that no information has been modified by them, access conditions are compiled with, updation of information has been done complying with the set rules, no interference has been done with the lawful use of technology and to obtain the information.